Hi, it's 5:31 p.m., July 26th, Tuesday, and by 6 o'clock you're going to know a lot more than you know right now about creditor protection for the single physician. And if you're a single physician, you're going to know a lot more. We have a lot of very well-qualified CPAs on this call. I am really impressed that each of you has taken the time to listen tonight. And of course, to those of you who are physicians and maybe more importantly spouses of physicians, we're going to have something for everybody here. Now, you are hopefully watching the PowerPoint. If you have any questions or problems, you can call Janine, 727-442-1200, extension 8, and Janine will answer and help you out. And if you have any questions, if you email Janine, Janine, at gassmanpa.com, the same email address you see there for me, she will hand me the question and I'll answer it. So, going to tab 1 or page 1 on the PowerPoint, it was not raining when Noah built the ark. So it's really best to get the word out to clients and for you doctors to think about this before the jury trial, not the week of the jury trial, and hopefully before you even would get a bad result for a patient or a car accident. A few quotes that I think are instructive here. Of course, Murphy's Law, we hope for the best but plan for the worst. F. Lee Bailey, anyone who acts as his own lawyer has a fool for a client, and I think a lot of CPAs are very aware of that. People who do their own tax returns maybe have a fool for a tax preparer. Then perfectionists don't always win. A lot of the techniques I'm going to show you here have worked very well in the real world, although if you get an A-rated bankruptcy lawyer, they may tell you it may not work. Well, what's their better alternative? You want to make yourself into a porcupine here. Yes, a dog can eat a porcupine, but no, a dog usually doesn't eat a porcupine. And then finally, from the estate planning standpoint, don't handicap your children by making their lives easier. You want to do your estate planning so that everything doesn't just go directly to children who are going to lose it or spend it too quickly. All right, page 4 of the PowerPoint, a little checklist, some of the things we're going to follow and maybe something that you can print out or go over with clients. Number 1, do they have malpractice insurance in place? Do they have a corporate malpractice insurance policy? Number 2, do they have umbrella liability insurance in place? Number 3, are they properly investing their IRAs and pensions? Those are protected as long as you invest them properly. Number 4, is the homestead under half an acre within the city limits? If it's within the city limits and it's more than half an acre, you might want to think about some planning. Number 5, do you pay off the home mortgage, which is always going to be creditor protected, as opposed to doing other things because that's your safest asset, as we'll discuss. Number 5, are there annuity contracts and life insurance policies with cash values? They need to be owned by the doctor individually, not by a trust or somebody else. And are they worth doing because of all the expenses you incur when you buy them? Number 6, what do you do with the cash value of these investments? Number 7, have you set up 529 plans for potential educational expenses for children, nephews, nieces? Those are creditor protected and very easy to control. Then what do you do with non-homestead real estate? Next, with the real estate or whatever else you have going, are you covered in case somebody gets hurt when they rent your real estate? Is that in an LLC or a similar entity? Number next, should you consider charging order protection for your assets that are not otherwise protected? Should they be in an LLC or a partnership that will give you charging order protection? Next, do you have trust systems in place for your children, nephews, nieces, other loved ones, future spouses that help put the rest of everything in place? Most importantly, at the end, do you have a team of qualified and caring advisors, including a CPA, investment advisors, a qualified lawyer, and good malpractice and personal liability insurance agents? Is everyone working as a team? Is everyone in touch with everybody? This can be vitally important. So hopefully, if you're a doctor, you can use this checklist. If you're an advisor, you can use it many times. Okay, The introduction, of course, a single Floridian situation is more challenging because you can't hold assets jointly as tenants by the entireties. Also, you do have these words exempt, which is what a creditor cannot touch under the Florida law, and you have the words non-exempt, which are assets that are exposed to creditors. So when I use those two technical terms, that's what they mean. And then you have some assets that may not be totally exempt from creditors, but they're hard as heck to get into. That's the porcupine approach, things like limited liability, limited partnerships. And I mentioned here for you CPAs and also for some of the doctors, you may see an entity called a limited liability partnership. The initials are LLP. That does not offer charging order protection. Yet a limited partnership, known as an LP, or a limited liability limited partnership, known as an LLLP, does provide creditor protection. So this is a complicated area. You definitely want qualified people to be looking at your situation to make sure that there are not mistakes made. It's hard enough for those of us really dedicated in this area to avoid making mistakes. All right, I've got this one-page summary of the creditor protection laws that I will cover in 2 minutes. Now, I'm going to reiterate a lot of the things during the presentation. I personally think it's best for short-term and long-term memory to give you a few concepts a few different times. So at the risk of repeating myself or intentionally repeating myself, on the left-hand side, I have the creditor-exempt assets. The best, because of the Florida Constitution, is the homestead, up to ½ an acre within the city limits. And even if you make a fraudulent transfer, a transfer at the very last minute into your homestead by paying off a mortgage or buying a new homestead, as long as you stay out of bankruptcy, the creditor cannot set it aside. So we do have clients who have put substantial monies, basically everything they could get their hands on and everything they could borrow, into a homestead, even with a creditor imminently approaching them. And the creditor's choice is to wait until they eventually sell the home or to try to force them into bankruptcy, which is almost impossible to do in most circumstances. We'll talk about that a little bit later. Next, your IRA and your pension accounts. These are absolutely creditor protected. Now, if you have somebody who's pursuing you as a creditor and you fully fund a 401k or an IRA, that last thing you put in might be a fraudulent transfer and have to come back out. But otherwise, these are very safe. They should be invested very carefully. I spoke to 2 different doctors today and asked them to please have their CPAs review the investment plans for their IRAs and pensions. Sometimes people who sell investments get a little bit carried away on the commission side, and they don't do what's always in the best interest. So you've got to be real careful. This is your most valuable investment asset because it's the most creditor protected. You're getting a tax deduction for setting it up. Please be very careful with it. Permanent life insurance must be owned by the insured person to be protected, like I said. You want to make sure the beneficiary designation is also set up so it will be protected in case you die. Annuity contracts, which you can buy these on a no-load basis from Vanguard. The total charge is less than 0.7% a year, including the mutual fund component. Or you can buy them from your investment advisor, in which case you should be very aware of what the expenses are, but they are creditor-proof. The wages of a head of household. Now, if you have your own medical practice, you can control what comes out as wages and what comes out as dividends. And what comes out as wages may be a protected asset. We're going to talk more about it later. It's at least an asset that you can try to have protected, and it might go directly into a 529 plan or an annuity contract or a limited partnership account so that it stays creditor protected. Then the wage account, there is a Florida statute that says if you take a protected wage check and you put it in your wage account, it's protected in the wage account for 6 months. But by my experience, people forget to transfer the money from the wage account. So I like those wages going directly into something protected, as we're going to discuss later. Tenancy by the entireties, I'm sorry, but you have to get married in order to have the advantage of tenancy by the entireties. And in Florida, you have to marry somebody of the opposite sex. So if that bothers you, we can't help you with that right now. 529 college savings plans. These are a fantastic program. All 50 states have sponsored at least one of them. They are very similar to mutual funds, and as long as you spend the earnings from the 529 plan on college or college-related expenses, including graduate school, you never pay income tax on the 529 plan. All the major brokerage firms have them. All the no-load mutual funds have them. They are a fantastic thing to have. And having paid now for 13 years of graduate school college and graduate school for 2 children, I can tell you I highly recommend them. Again, annuity contracts, I've just repeated that here by accident. Okay, now the assets that are not totally protected, but they can be hard for a creditor to get hold of. And many, many creditors, when they see you have these things, they'll just say, oh, that's too hard. We'll settle for the limits of your liability insurance, or that's too hard. Please give us just $50,000 and a deed in lieu of foreclosure. These are properly situated limited partnership, limited liability, limited partnership, and LLC arrangements, foreign trusts, foreign companies, which we don't do very many of, but I have to say it is a porcupine, foreign bank accounts, which are not even as good, but a lot of creditors will, be less likely to pursue them. I don't encourage clients to directly own foreign bank accounts, though. And then the assets that are exposed to creditors, your bank account, your brokerage account. If you were married and both spouses owed money, that would be exposed. Your furniture, your car. In Florida, you just have a $4,000 exemption at best. So your car, your furniture, your jewelry, all that is exposed. Some clients put cars and furniture and jewelry into LLCs. With the car, that can run the insurance up. But it's just covering the basics here. It's things to think about. Vocabulary, I mentioned an exempt asset before. I mentioned charging order protection. I want to talk to you a drop about fraudulent transfers. Now, you know not to commit fraud. You know not to lie to anybody. You know not to mislead anyone, especially a financial institution or your parents or your lawyer. But there's something else called a fraudulent transfer. And under the fraudulent transfer rules, if I owe money to you, and instead of paying you, I transfer all my money into an annuity contract, then you may be able to set that aside and get the annuity contract monies back out, and I will have committed a fraudulent transfer. And Florida has a 4-year reachback on fraudulent transfers. So if I do a fraudulent transfer to avoid paying you, and you pursue me in court within 4 years, you may be able to set it aside, even if I go into bankruptcy. So if you're going to do a fraudulent transfer, do it right away, and put the best tilt on it that you can. If there's business reasons for you to be putting money into a 529 plan to pay your children, if you have somebody you want to invest with that you put real estate in and they put money into an LLC and you have charging order protection, you need to talk to a lawyer before you make anything that might be a fraudulent transfer. But if your brother-in-law is a lawyer or your sister-in-law is a lawyer and they tell you you can't make a fraudulent transfer, talk to another lawyer, because sometimes it's actually best to do one, especially if you have at least a year before you would ever have to file a bankruptcy. Okay, page 7. And by the way, forgive me for being somewhat gruff here and maybe aggressive, but I want to give you as much information as I can in 30 minutes, and I want to dispel some rumors that you may have already heard. Now, on page number 7, some other definitions. The debtor is who owes the money. The creditor is who is owed the money. The judgment is when the judge says the money is owed. I may agree to pay you money. I may sign a promissory note, and then I don't pay you. There's really nothing you can do under Florida law until you have a jury trial and prove that I owe you the money and the judge says I owe you the money. And then you're the plaintiff in that trial, I'm the defendant, and even after you get that judgment, you can't touch my exempt assets, You can send the sheriff in or garnish my bank accounts or otherwise to get the non-exempt assets. If I made a fraudulent transfer, you can try to set the fraudulent transfer aside. If I made the fraudulent transfer into my homestead and I try to bankrupt you out, then my homestead exemption is going to be limited to $136,875 under the Florida law, under the bankruptcy law. If I bought the homestead within 1,200 and I believe 25 days, then you can set it aside if I end up in bankruptcy. If I've lived in the homestead for less than 730 days, you can set it aside if I haven't lived in it that long before I've gone into bankruptcy. So because of those bankruptcy rules, it's a great idea to have whatever home size you expect to grow into a little earlier rather than later. But please don't get carried away and buy a $3 million home, and then when you retire, the only thing you own is a $3 million home because you spent all your money paying the mortgage payments on the home. Don't get carried away with the homestead. Keep the homestead under half an acre if you're within the city limits, or you'll have to use another technique that we'll talk about. And those are the preferential transfer rule on page 8. Is if you make a transfer to one creditor within a few days of going into bankruptcy, or within a year if they're related, or within 2 years under the Florida statute, then that may get set aside. So we want to be careful here. Now I'm going to skip some of these other definitions to make sure that we have enough time. Joint and several liability is when you and another debtor owe the money at the same time. They can go after either of you. Whoever they get first owes the money. Secured interest is when somebody has a mortgage. It's called a UCC-1 financing statement for personal assets. It could be called a pledge for stock, but you would give a creditor, a lien on assets, and then the other creditor can't get hold of them. For example, if I owe my parents $250,000 because they loaned me money to go to college, and then they have a lien on all my assets, and then you get a judgment against me, I would be able to go bankrupt, and if my assets are not worth more than $250,000, I wouldn't have to pay you as a creditor. And you wouldn't be able to touch those assets until you paid my parents what they were owed. So sometimes it's a good idea to put liens on assets. All right, going to page 14 here. And by the way, everybody is welcome to print out any more of these pages and to use them in your practice or personally. This is the chart, asset protection planning for the single physician. Here's the individual person. If you look at my cursor there, they have their car, which is exposed, so you don't want to buy a Rolls Royce if you're single, or if you do buy a Rolls Royce, you probably want to keep a car loan on it. Then you have an IRA, pension plan, annuity contracts, life insurance. You might have a wage account. You might have 529 plans. You might have Gift to Minors Act accounts for your children. Those aren't yours. Those belong to the children. You might have the children's cars in their names. And you might have your homestead. And all of those are protected assets. So if you're a well-to-do physician, are you positioning enough assets in these categories that if things ever went badly, you would be able to survive? And then if you have an awful lawsuit, and an awful plaintiff lawyer who's going to chase you to the end of the earth, there's nothing they can do about these assets. So that would tilt me towards having more of these assets and less of the other things. Okay, then you have your medical practice company. You might be inclined to have a bank loan you money against the medical practice. LLC ever makes a distribution, the creditor has to be paid before the owner is paid. So you'll be able to say, sorry, creditor, I'm a porcupine. You have a charging order. You might even be able to send the creditor a K-1 form and make them pay the income tax on the rent income. The law's not clear on that, but I would sure try it. And at least then you have continued use of the building, and your grandchildren will at some point in time deal with the creditor's grandchildren and get this solved. Typically, these cases are settled on 5 to 10 to 20 cents on the dollar when you have the charging order protection. Now, if you have a securities account and you don't have it under an annuity, you don't have it under a 401k, consider getting an LLC or a limited partnership. It'll work the same way. Gift small percentage interest in that to the gifting trust, and make sure that your accountant is tracking that LLC, tracking that limited partnership, doing some sort of financial analysis to make sure that the percentage ownership is correct, preferably filing a partnership tax return to show that this is a real entity that a creditor would only be able to get a charging order out of. Okay, now if you want a little bit more protection, here's another real estate limited partnership. And what the client did with this to get a little bit more protection than just charging order is we set up an offshore asset protection trust. Now, I cannot tell you that I feel nearly as good about an asset protection trust as I do about pension accounts, homestead, annuities, life insurance, because Florida law doesn't provide for protection of offshore asset protection trust. It's the offshore law. The reason being that offshore law says that if you put an asset into an offshore trust, creditors can't get it no matter what. You just have to continue paying the offshore trust company and everybody's happy. And in fact, all the CPAs attending this today are going to receive a copy of a webinar PowerPoint that we presented for B&A on protecting domestic and foreign assets using creditor protection trusts and dynasty trusts. And I will welcome any questions you might have on that. I cannot share the soundtrack, of course, because that was proprietary to B&A, but Stephen Oceans and I gave this today. He spoke on the Nevada Limited Liability Company and Nevada Creditor Protection Trust, and I spoke on the rest of the world and Florida trusts. If you don't want to go offshore, you can use a Nevada or an Alaska Creditor Protection Trust. If there's going to be S corporation stock involved, it needs to be under a domestic trust. Nevada has some new laws that make it superior to Alaska, but I don't think I need to go into any detail here. And of course, get a prenuptial agreement from that new loved one before you love them so much that you have to marry them without a prenuptial agreement, or only date people who have a lot more assets than you do, or at least a lot more income than you do. Prenuptial agreements work 95% of the time or more. Okay, page 15, a little bit more in depth. If your homestead is more than half an acre, then you can place it under a separate entity. You could take the half an acre and keep that in your name, survey the rest of the property that's not under the roof and not on the lakefront or the waterfront, and put that in a limited partnership. And then you can lease it for 99 years and keep your homestead exemption. And I know I'm going fast here, but I want to make sure that I finish on time. Now, also, these creditor protection laws, just something for the doctor. The homestead creditor protection goes down to $136,875 if the person is hurt by willful or malicious misconduct. Now, if I'm a doctor and I routinely don't really read the x-rays and I'm really, really sloppy, then something I do to somebody might conceivably be called willful or malicious misconduct, and I could lose my homestead in bankruptcy, would not be able to bankrupt out a judgment. So again, I would not get too carried away with the homestead. It's a good asset, but we are seeing plaintiff lawyers filing lawsuits alleging willful and malicious misconduct now, and I know why. And also white-collar crime. If you get implicated in a white-collar crime like a securities violation, then the homestead protection can be lost. Now here's a chart. Next time I give this presentation, I'll put it in the right place, but this is where you would keep half an acre and put the overage property into a limited partnership owned mostly by the client, partly by the children, lease the property back on a 99-year lease, and then you can keep the homestead exemption for state law purposes and the 3% cap, but you would have charging order protection if somebody sued you. And we've done a number of these, and they have been successful as far as getting things settled. Pension plans and IRAs, please make sure that your CPA or somebody is filing the Form 5500 and properly administering the plan, and that all the right employees are on that plan. Because the plaintiff lawyers will look at these plans, and if they find a way to report you to the IRS to disqualify the plan, then they might be able to reach into the plan. They get the money, you pay the income tax in your after bankruptcy dollars. It's not a pretty thing. Annuity contracts, I discussed them at page 22. For the CPAs, if you're going to put $1 million of client money into an annuity structure, buy 10 $100,000 annuities. Here's why. Florida will insure, the Florida state will guarantee up to $100,000 per annuity, up to 3 per carrier. Secondly, if I put $1 million into one annuity and it grows to $1,060,000, the first $60,000 I pull out is going to be subject to income tax at the 45% bracket. On the other hand, if I do 10 $100,000 annuities, then if they all grow by $6,000 and I need $100,000, I can pull $100,000 out of one of them and only pay income tax on $6,000. That's why I have a lot of clients who own a lot of $100,000 each annuities. Also, if they're variable annuities with guarantees, you can have each one in a separate investment class, and you might find that those guaranteed value clauses actually work when one investment really skyrockets because it's a little bit out of the allocation class. Again, your personal assets, good thing to have a bank loan against them. Good thing that they're not worth so much. A few clients got carried away with gold and are holding a couple $1 million in gold under limited partnerships. That's feasible. Of course, those clients, I told them not to do it. They put $700,000 or $800,000 into gold. Now it's $2 million worth of gold. So don't listen to everything that your lawyer tells you. Just please listen to most of what we tell you. Okay, the wage accounts, again, there are cases where the courts have not allowed wage account protection, but all of these cases say that if there is a written employment agreement which provides for fixed periodic wages, and these are actually paid, then the wage account would hopefully protect the client. So CPAs and clients, if you look at the chart on page 28, you've got to really decide when you have this practice entity, maybe it's an S corporation, maybe it's a C corporation, what are you going to pay in wages? Is there a written employment agreement? Can the doctor take those wages and put them directly into annuities or a limited partnership or another protected account? And then whatever dividends you pay, which are not subject to employment taxes, the doctor can live on. So I try to get clients to live on the dividends and save their wages. Of course, you may have children on the payroll. They earn some money. You give them money. They put it into an IRA, a Roth IRA. It's there for their education. Your pension plans, you want to fully fund. Talk to your CPA about making the most of your pension plan. Your spouse on the payroll, well, you don't have a spouse on the payroll. Maybe you have a significant other on the payroll. Maybe you have a parent on the payroll. Get everyone involved. Everyone needs to work. Pay rent to a protected entity. And are you paying interest to related parties? If you borrowed money from somebody you love, are you paying them a healthy insurance rate? Don't drop your liability insurances, please. That's on page 30. Discussion on page 31 about family limited partnerships and LLCs. We have a new law that protects LLCs if the operating agreement has the right language. CPAs, please don't let the clients just form the LLC. Let us or somebody look at those operating agreements to make sure that the statutes don't override the operating agreement. If there's no operating agreement, then it may be required that an insolvent LLC member would have to put their stock back to the LLC and get cash, and that would have to be given to the creditor. So please don't fall into that trap. Get yourself some friendly creditors in first place. that bank that you like and has a lien on your building and your personal assets may be the best protection you can get. If you're going to consider an asset protection trust, that's great. Be very careful. Don't go to an asset protection trust mill where they promise you great results. These things have not been tested in court, but over all these years, the reason they haven't been tested in court very much is because no one wants to pay all the money to try to contest them. So they might be good porcupine devices. If you do a foreign one, make sure you do the proper tax reporting. Then whatever activities you have in your life, try to get firewall protection. If you have a rental property, a company going on, partners in a deal, move this under an LLC or a limited partnership so if there's a lawsuit, it hopefully will not directly attach to the doctor and the doctor's assets. And then finally, I'm sorry that I went too fast, but hopefully you learned a lot today or you got a good refresher. Remember, it was not raining when Noah built the ark. He worked hard. He had just enough time. You do have statutes of limitations. You do have dangers. Please, you pay a lot for insurance. You save a lot. You work hard. Do what you need to protect these assets and get your estate planning done also. Okay, any questions you might have, I'll be glad to answer. If you just want to send me an email, I do have a couple of requests for us to forward the materials to you. I'm glad to do it. Please share this with anyone you like. Tomorrow sometime this will be posted to our website. Everyone's very welcome to look at it for free. Thank you for all of the confidence you've had in our law firm over the years, both physicians and advisors, and have a great evening. Thank you.